This is Hannibal here from the HannibalTV.com with some very interesting news that's come out. Vince McMahon has filed a response to Janelle Grant's accusations, which is pretty interesting. I'm gonna share. Okay, let's share the screen and look at some of this. Or you know what? I'm gonna do it as a sorry. I'm just gonna share my screen and we'll go over Vince McMahon's response to Janelle Grant's claims that's kind of just been released, and I'm reading it for the first time with you. So let's go into it. All right. So this was filed in the District of Connecticut, United States. Plaintiff Janelle Grant versus WWE Vincent Kennedy McMahon and John Laurinaitis. And this is a motion to compel arbitration. And let's skim to the meat of it, since we've only really heard Grant's side of it. Okay, so he's saying by publicly filing her salacious, false, and defamatory complaint, plaintiff has brazenly and intentionally violated a binding contract to arbitrate. And I don't know if this has to do, like, I know for the job I work with, if you have a legal issue with them, um, you have to go through arbitration prior to going legal. Like with my shoot job, I can't just if there's an employee issue, I can't just take it to court through an outside lawyer. It has to be arbitrated. So I don't know if this is the same thing or not. Um, I did ask a lawyer friend if he would go through this with me. Basically says, contrary to the plaintiff's false allegations, the plaintiff and defendant, collectively known as the parties, engage in a consensual relationship during which the defendant never coerced the plaintiff into doing anything, never mistreated her in any way. In fact, in a love letter the plaintiff wrote to the defendant shortly before the parties ended their relationship, the plaintiff described the defendant as my best friend, my love, my everything, praising him for being wonderful, tender, vulnerable, heart on your sleeve, soul, you really are. He says that the plaintiff then, when she wrote that, was 42 and claims to have a law degree from Pace University. Why would she have written these words months after all these alleged events where she's alleging abuse, coercion, and sex trafficking? That is a point. If she did have a law degree and she's 42 and all this happened before she wrote that, she must have known. I mean, because she's trying to claim that he forced her to write that. But if she does have her law degree and all this, wouldn't she know the ramifications of writing a letter like that? He goes on to say, at the time the parties met in 2019, plaintiff was not dealing with the profound grief of her parents' death and struggling financially, as described in her complaint, and she had not been devoting years to around the clock caregiving of her parents. Those statements are complete falsehoods based on a foreclosure action against plaintiff and her parents. Plaintiff's father passed away on April 18th, 2017, 2 years before the plaintiff met the defendant, and his marital status was recorded as widowed, confirming the plaintiff's mother had passed earlier. Court records further show that contrary to her claim of around-the-clock caregiving, Plaintiff's father actually lived in a senior care home in Stamford, Connecticut before he passed away, not with her. And Grant's neighbor would bring plaintiff's mother dinner and help around the house before she passed. Goes on to say, in fact, contrary to her story of around the clock devotion in the complaint, the foreclosure action on her parents' home revealed that the plaintiff was adamant that she did not want to be associated with any of this and failed to respond to requests regarding the foreclosure action. Affidavit of due diligence basically says the plaintiff was so absent in her parents' lives that it took substantial time and significant effort for the creditor in the action to locate her and identify her as her parents' next of kin. And it goes on to say, in addition to the falsehoods about her own background, the plaintiff's complaint is further riddled with fabrications and omissions about her relationship with the defendant. Plaintiff and defendant knew that the other was also involved in other romantic relationships. Plaintiff was living in Park Tower. And this is something I always found weird. We're trying to act like she's poor. Okay, that's my opinion. How can you live in this luxury apartment if you're so poor? So it goes on to say the plaintiff was living in Park Tower, a luxury multi-million dollar building in Stamford, Connecticut, with her longtime fiance, attorney Brian Goncalves, since August 2022. And I'm probably pronouncing his name wrong. Goncalves had served as senior vice president and chief privacy officer of Televisa Univision and previously held positions with MasterCard and Hewlett Packard, whatever that is. Plaintiff and Goncalves lived in the same luxury building as the defendant. Yes, the same building that Vince McMahon lived in, a multi-billionaire, just four floors below, when the parties began their affair in 2019. So, in other words, this woman allegedly also was with someone. The plaintiff would also often visit the defendant at his condominium at all hours, including at 2:30 a.m. to pursue their affair, and then return back to her condominium with Goncalves the same night. It is non-essential that the disturbing alleged acts in the complaint, including videotape, coerced sex, and forcing plaintiff to be defecated on, were taking place before the plaintiff returned to her lawyer fiance's 4 floors below without incident. So he's basically saying that all this stuff was happening that she allegedly had a problem with while she was still with this other guy. The defendant was never contacted by this guy she was with, Goncalves, which I'm pronouncing wrong, I'm sorry, who was on the board of the luxury building. Anyone at the building, the police, any friends of the plaintiff, or any lawyer or advocate for the plaintiff at any time about the fictitious, extensive, year-long abusive behavior alleged in her complaint. After 3 years and having decided to return to their partners in January 2022, plaintiff and defendant agreed to end their consensual affair and separate from each other, with plaintiff leaving the company where they worked, World Wrestling Entertainment. Plaintiff and defendant entered into a binding contract to memorialize that agreement entitled Confidential Settlement Agreement, General Release, and Covenant Not Set to Sue. Plaintiff initially wanted to include a term in the contract mandating the defendant could not move out of their shared building, but the defendant refused to include that term and did move out. Plaintiff's contention that the contract between defendant and WWE on the one hand and plaintiff on the other is not enforceable and utterly meritless, but that is an issue for the arbitrator. In fact, because the parties wished to preserve the confidential and private nature of any dispute under the agreement, they specifically provided in the agreement that disputes would be resolved through arbitration. Plaintiff was represented by a lawyer who negotiated that agreement before she executed it. When the defendant learned that the plaintiff, despite her promises, had violated the agreement by wrongfully disclosing both the existence of the agreement and their relationship, he exercised his contractual right to withhold payment otherwise owed under the agreement. In other words, this is me saying it, she talked about it, which is why he never paid the rest when she signed a non-disclosure in exchange for accepting money. In response, plaintiff sought to harm him. She intentionally violated the enforceable contract with her salacious, false, and defamatory public filings. However, the FAA and binding United States Supreme Court precedent and the plaintiff's own argument require that if a plaintiff wishes to proceed with her fictitious claims, she must do so in arbitration, not in court, and that this action be stayed pending arbitration. This is a pre-answer motion. Defendant does not specifically address the substantive merits of the counts plaintiff's counts asserted against him. For the avoidance of doubt, however, defendant vehemently and categorically denies all allegations of wrongdoing in the complaint, including the outrageous claims that the defendant coerced, um, sorry, plaintiff, defendant coerced plaintiff into unwanted sexual acts, sexual assaulted and battered her, trafficked her, and defecated on her. So Vince McMahon is denying taking a crap on her. He says those are false statements intended for publicity. When the complaints allegations are adjudicated in the proper form, witnesses are called to testify under oath, and all communications between the parties, including those authored by the plaintiff, which she intentionally did not share with her complaint, are produced. The allegations and claims will be disproven, and the plaintiff will be exposed for the liar she is, according to this. Meanwhile, for the foregoing reasons and set forth further below, defendant's motion should be granted. So here we go. We'll start with the background. Plaintiff is 43 years old. She was born in 1980 to her parents, Jane Grant and Anthony Grant. Grew up in Mount Crisco, New York. From approximately 1999 to 2002, she lived in LA, pursuing a career in acting. In 2001, she bid in an auction to be featured in the film Who Wants to Be a Movie Star, and as one of the actors with 5 lines and under. Subsequently, in 2006, plaintiff was featured in the film The Theory of Everything as a hospital receptionist. So I'm sure all these pictures of her in these films are going to come out now. Plaintiff also spent the majority of her childhood and adult life as an equestrian rider and owning horses. So yes, that's a very expensive hobby. That's not a poor person's hobby. According to another lawsuit filed by the plaintiff against several defendants for alleged injuries sustained by the plaintiff's horse, plaintiff had moved back to East Coast by 2012 and was actively involved in the equestrian community at the same time. When they met, the plaintiff told the defendant she had received a law degree but had not taken the bar exam. Based on her representation, the defendant assisted the plaintiff to set up meetings with the WWE Human Resources to apply for a position in the legal department as a legal administrator / coordinator. The agreement's negotiation and monetary terms says the parties' consensual relationship during which the plaintiff was engaged to this other guy, Gon Calves, strange last name, and resided with him in the luxury apartment, lasted a little less than 3 years and ended in about January 2022. On December 24th, 2021, Shortly before the parties' relationship ended, as was reported in the New York Post, Grant penned a lengthy email to McMahon in which she claimed, "My best friend, my love, my everything." They then negotiated an agreement under which the plaintiff would receive money compensation in exchange for an consideration of various mutual promises and covenants. The plaintiff negotiated on her own behalf in this instance. The defendant initially intended the monetary consideration to the plaintiff under the agreement to be in the range of $1 million to $1,500,000. Plaintiff negotiated the monetary provision in the agreement by telling the defendant that his initial offer of $1 million was not enough to compensate for the loss of earnings potential and the fact that she would be unable to continue with the promised career trajectory of vice president, as well as failing to last as director for a full year. She negotiated the monetary consideration to a final amount of $3 million. As another example, the plaintiff also demanded that the $3 million was to be paid in a lump sum. A comparison was ultimately reached, or compromise was ultimately reached, such that, as the agreement states, the first million was to be paid upon the execution of the agreement, and the rest was to be paid in 4 installments. And here we go, monetary considerations to Grant. Upon execution of this agreement, McMahon will pay the lump sum of $1 million to Grant within 10 days of the execution of this agreement. Provided all confidentiality obligations of Grant under this agreement are complied with, in ensuing years, McMahon will pay the following sums to Grant within 10 days of the dates listed below: February 1st, 2023, February 1st, 2024, 25, 26. In the event of any disclosure by Grant the matters required to be kept confidential under the agreement, McMahon shall have no obligation to make any payments set forth above which would otherwise become due on the dates indicated, and all the monies previously paid to Grant in this agreement shall be returned to McMahon in accordance with the terms of this agreement. So in other words, if she talks about the stuff she's signed in order to get all this millions of dollars, the agreement would be off, and she would technically have to repay, which I don't see that happening, being repaid what she has already. As the plaintiff admits in her complaint, the parties each retained counsel who were involved in the drafting, editing, and negotiations this agreement. Indeed, in the course of negotiating the agreement, the plaintiff's counsel, in an effort to reinforce the strength of the arbitration clause, proposed that the following language be inserted: in the event of a claim or breach under this agreement by any party that results in arbitration or any legal proceedings, the prevailing party, as determined by the tribunal or court, shall recover from the non-parties all of its resulting costs and attorney fees. Although the finalized agreement did not incorporate the proposed language verbatim, the arbitration provision states that the prevailing party in the arbitration shall be entitled to recover from a non-prevailing party all of its attorney fees and costs. Goes on, the agreement's release of claims. The agreement signed by all parties January 28, 2002. Parties mutually agreed to the release of any claims they may have against one another. Specifically, plaintiff agreed, among other things, to release the defendant of all claims she have ever had as a result of or in connection with her employment relationship with the WWE, termination of that employment relationship, and or any and all matters involved in her relationship with Vince McMahon or other WWE personnel. The agreement states further, by signing this agreement, Grant acknowledges that she will have waived any right she may have had to pursue or bring a lawsuit or make a legal claim against McMahon and WWE and any of its directors, officers, employees, agents, and representatives. Still further, the agreement states that Grant agrees that she will not cause and has not caused to file any legal action, administrative proceedings, arbitrations, or changes of any nature, charges of any nature relating to Vince McMahon or WWE, considering matters within the scope of this arbitration And it goes on and on. These are the details of the agreement. So I'm not going to read each and every one, but it's clear there was an agreement there, a confidentiality agreement. The reason that she went public is because supposedly he didn't pay the rest of the agreement, and he's saying because she went public, there's no reason to pay the rest. So she has, I believe, filed a motion to have this motion struck, this motion for arbitration, but which could happen. But now we at least know Vince McMahon's side of it. I'm not very familiar with Epstein, but I'm sure there's been many females in the wrestling business that I mean have benefited from various relationships over the years. ATF media, does it all does it all at all blame CTE for being punched by the hands of Stone Ronnie Garvin? I mean, anyone that's ever been punched by Ronnie Garvin would definitely have CTE. But let me know what you think of his response. I mean, some of this seems to make some sense as far as their relationship. I mean, I never believed she was poor. They were trying to make her out as poor. She lived in a luxury building. As far as whatever bizarre, here's another thing that is true. She accepted a hell of a lot of gifts from Vince. I've already done a video of all the gifts she accepted. We didn't know she was with another guy. We didn't know that this guy she was with and her have a law background. Um, and whatever happened, she appeared to sign a confidentiality agreement that she ended up breaking. So I don't know. I think they should go to court on this or arbitration. I think we should let this play out. And I could see him taking this, not settling it because she didn't follow through with the first settlement, and his reputation has already been damaged. So why not go all the way with this? Because a lot of people, most people are going guilty until proven innocent here. So what does he have to lose by fighting it? Yeah, it seems like the only pictures are for 25 years ago, but people could look up now the movies that Vince McMahon says she was in to find recent pictures of her. Very simple. I noticed some people like in some comments that, oh, she looks so innocent. You can never judge a book by its cover. I've been with not a massive amount of women, but a decent amount, and sometimes the most innocent looking women are the naughtiest, and some that look the naughtiest are the least sexual. There's no way of guessing by looking at somebody. Someone thinks it's going to go to arbitration. Yeah, there's obviously dirt on her and holes in this case, and Vince McMahon's lawyer is the same lawyer that was involved with the MLW lawsuit. I don't take sides on this, but I just never thought she was poor, and I don't think she's as innocent as she made out to be, and she never got the police involved, and clearly she has a law background. And honestly, if I'm not saying a rape didn't happen, we'll see what happens in court. But if something terrible had happened and she had gone to the police right away, I mean, there would have been a criminal investigation. If you can't find a recent picture of her, look up the movies that I stated earlier here, where Vince said she was in a couple movies. I'm sure you guys could find screenshots. Yeah, the plot thickens. Do I think Vince McMahon, someone asked, is going to buy another Fed? I don't think he's going to buy another federation. I think he's going to start another federation. I mean, if you look at I just talked about it in the news, but after AEW, it's a long way down to TNA. They only averaged 200 fans a show last year. AEW is losing a lot of interest lately. Vince McMahon created WrestleMania. I think there is potential of him starting a new league, particularly if he could clear himself of this. Do I think Endeavor was behind this going mainstream? Who knows? I do find it interesting that this all came out after the Netflix deal and Kevin Dunn retired in December. I think more people knew what was going on than meets the eye. But again, I'm just a follower and an observer in this. Um, anyways, someone says if she got paid, I'm not gonna repeat that. I really don't know the rules state by state, but I don't know enough about all I know is she ended up with a WWE job out of it. She got a long list of gifts. She did get, don't quote me on this, but I think she got 1 million to 1,500,000 before he stopped paying her. So she got a lot of money. Did she get the 3 million? No, but apparently it was because she didn't keep quiet about it, which was part of the settlement agreement. So we'll see. WWE owns ECW, so don't expect that to start back up. Who would jump in his new fed? Who he is a multi-billionaire. He is a multi-billionaire with endless amount of cash, and he's if he's not 80, he's almost 80. So he could definitely recruit. And there is a lot of there's talent out there, and there's been no one better over the years at creating stars than Vince. Obviously, he's not in his prime anymore, but he could be a formidable competition. I mean, I'm not going to diss WWE or AEW, but those products to a lot of us that were fans of the golden era of WWE and the Attitude Era are not fans of today's wrestling. So there's still fans out there looking for an alternative. Someone thinks Vince is not guilty. Louis would work for Vince. Oh my God. Very funny. Mike, I would love to interview Robert Fuller again. I would love to. David began as a correction officer in Missouri. Apparently, the um, academy right now in the facility he works at is the house of former UFC fighter that was decently successful. Cool. Someone says if Vince Brad bring, you know what I think would be if Vince had a new league, it would be ECW-ish, as if it would be like the type, you know how I've been saying like WWE hires very corporate people with very few exceptions. All the wrestlers are very corporate. Cody Rhodes is like the perfect example of a corporate WWE wrestler. AEW is a very politically correct organization and very smart mark oriented. It would be good to have like a badass organization that wasn't corporate and wasn't necessarily politically correct. Wrestling desperately needs that because wrestling has never been it was built on not being politically correct. And now it's so politically correct that it turns so many people off. Undertaker is he probably will wrestle again if there's enough money, but I mean it doesn't matter if he could follow Vince or not because he's at the end of his career. But Lesnar, I don't know how long his contract is left. Goldberg has publicly stated he won't go to AEW. Who knows? We need a new Jack Ter. We do need more edgy characters, as this person says. There needs to be edginess back in wrestling. And as I said, WWE is corporate as corporate can be. TNA, sadly, they have some good wrestlers. But I hope it becomes better. NWA is not even on anyone's radar. MLW is not really on anyone's radar. I mean, it would be great to have another product out there. Taker has lost his mystique. 100% he lost his mystique. Anyways, guys, I'm gonna call it a night. That was a very detailed report, half an hour. Uh, Very interesting. The plot thickens for sure.